Judge Kath might have told Beverly to hold her White Claw. Kinda looks like a Disney villain, doesn't she? But Silver Fox Timothy J. Bradl is clapping back harder than the fake victim in the comments section of a docking tutorial, saying, "You wrong." This and more in today's video.
You wrong.
Is this Higgins?
Is this Higgins? You wrong.
Hello, and welcome back, roommates, to another titillating edition of me trying to figure out what the heck to do with my hair on Alexasrewm, where we are not lawyers, we are not medical professionals, and we are not law enforcement. We are just people. People who have opinions about all things going on in the true crime community, including one Timothy J. Bradl sliding into the court's DMs to provide a physician's note. Jess Machado tweets the latest filing in the Kelsey Fitzsimmons case by Timothy J. Bradl, who also represents Turtle Boy in his cases, includes a letter from the physician who treated Fitzsimmons and details her injuries and physical limitations after being shot by a fellow officer on June 30th. And here is the doctor's note, which would have been handy for me back in high school when my PE teacher forced me to run the mile with a hangover. So this was in response to the dishonorable Kathleen McCarthy Neiman Marcus, who tossed Kelsey Fitzsimmons, the North Andover police officer who was shot in the chest, back in the clink because she couldn't play the court-ordered skin flute long enough to please the scram gods. To listen to the hearing in its entirety, make sure you click the link in my description box below and head on over to Jess Machado's Twitter X's and give her a follow.
To fashion the least restrictive conditions that will reasonably assure the appearance of the defendant and the safety of all other persons in the community pursuant to General Laws Chapter 276, Section 58A-2B. Just days ago, the court concluded that the condition of remaining alcohol-free and submitting to scram monitoring was necessary to ensure the safety of the community. After a thorough review of all of the arguments and submissions by the Commonwealth and Fitzsimmons, that conclusion remains unchanged, regardless of Fitzsimmons' claimed physical limitations. Based on an affidavit submitted by Fitzsimmons' mother, the testimony of Assistant Chief Probation Officer Jeff January about his observations of Fitzsimmons' apparent pain during the scram installation, and the representations of Fitzsimmons' counsel that it would be cruel and unusual punishment and torture to continue to require Fitzsimmons to comply with the condition of being monitored by scram. The court concludes that Fitzsimmons cannot abide by the condition of being monitored by scram. Without this condition, which ensures that she does not consume any alcohol, the court cannot assure the safety of Officer Noonan and all other persons in the community. Accordingly, the court's prior order of release is vacated, and Fitzsimmons is ordered to be held without bail pursuant to Mass General Laws, Chapter 276, Section 58A. And a written order will follow.
May I address the court?
That's the court's order. Thank you.
All right, Jack. I ask you to stay your order pending the SJC. And there are other alternatives Your Honor can accomplish.
So in other words, Judge Kath possesses all the same compassion as a truck stop glory hole. So now Bradl and his co-counsel, Martha Coakley, are swinging back with these fresh filings. Because apparently the Commonwealth requires a doctor's note, an affidavit, and probably a notarized letter from Jesus himself, just so Kath can be satisfied in knowing that when you get shot in the chesticle, it's probably gonna make breathing kind of hard. In the hearing that preceded the pending reconsideration motion, the court expressed its concerns that it desired medical evidence relative to Ms. Fitzsimmons' condition and on the assertion that her broken ribs could impede the deep breathing necessary for the scram device, causing pain and trauma to the defendant. The defense has obtained a letter from her surgeon addressing these concerns and corroborating Ms. Fitzsimmons and her mother's previously filed affidavits, and files a true and accurate copy here with footnote. The Supreme Judicial Court has always allowed the use of hearsay at probation revocation hearings. Commonwealth versus Durling. 407 Mass, yada, yada, yada. See also Commonwealth versus Calvo. 41, mass yada yada yada. Rescript. Unavailability of witness not required to be shown for admissibility of reliable hearsay. The revocation process should be flexible enough to consider evidence, including letters, affidavits, and other material that would not be admissible in an adversary criminal trial. So, in other words, rules for the criminal trial, like if this was during her regular jury trial, then no. But for all intents and purposes for this specific hearing, it doesn't apply. Similarly, the Supreme Court has sanctioned the use, where appropriate, of the conventional substitutes for live testimony, including affidavits, depositions, and documentary evidence. Wherefore, the defendant requests that an alternative means of alcohol testing be implemented, such as urine testing at Avar Health Systems, a Commonwealth vendor, 10 minutes from defendant's family residence, and the defendant be returned to her previously allowed terms of release, dated and signed on the 15th of yesterday. Well, you wanted a doctor's note. Here it is. Read it and weep, Kathy. In my medical opinion, a fracture of the 12th rib can cause pain that may persist for several months after the injury. The severity and duration of pain following such a fracture vary, and it is difficult to predict how long symptoms will continue in any given patient. Additionally, retained bullet fragments can also cause chronic pain. Surprise and shock and horror there, right? That can be exacerbated by movement such as deep breathing. I mean, what's next? A note from NASA confirming that water is in fact wet. So this is the original motion, the first one that was filed, the motion to reconsider imposition of custody and for reinstatement of original terms of release with order for alternative alcohol testing, which is the crux of all of this, right? As grounds, the defendant respectfully states that returning her to prison is not the least restrictive alternative to effectuate the court's aims and concerns regarding alcohol testing. Instead, the court can order an alternative to the scram testing, whereby the defendant submits random urine tests to the Avar Health contractor as set forth in the attached email from the probation department. Undersigned counsel has been informed by probation that there is a testing facility approximately 10 minutes from the defendant's residence where she can be driven as per the court's orders to be tested in a random fashion. The random testing involves the probationer calling every morning to see if she is required to go to the facility for random testing, hence the randomness. Her mother or father are available to transport her to that facility whenever the testing requirement is invoked. The court can accomplish its goals with this alternative rather than incarceration and without causing Miss Fitzsimmons undue pain. Yeah, because her sleeping on a cement block is not going to improve her condition, I would think. Undersigned counsel has been informed by probation that this testing method is available in this case. Thus, the court may order a less restrictive alternative than incarceration that completely addresses the court's concern over alcohol use and the safety of the community and any person without the severe alternative of incarceration. I mean, you took her kid away anyways. It's not like she can even see her kid, so... Which the whole point of all of this was, right? Is to make sure that she didn't see her kid. She couldn't get access to the kid. Defendant presented to the court that attempting and completing the scram caused pain at the time as well as 3 to 4 hours after. The court acknowledged she did not want the defendant to be tortured, but did not consider other alternatives that would accomplish the goal without pain to the defendant, even though she went into her chambers for a hefty, 5 to 10 minutes, right? What was she doing there? Throwing back a couple, like Bev? Pour one out for the homie, right? The court's revocation of all conditions to send the defendant back to jail is worse by far than even requiring her to submit to the scram. Aside from her total loss of liberty, the defendant is a police officer and former corrections officer who would face serious risk of bodily harm in such a facility. You know, I didn't even think about that too. Yeah, she's got the #1 target on her back. Also, as a former CO, heck yeah. Heck yeah, she would. Does anybody know where she was a CO at prior to all this? Ms. Fitzsimmons is requesting an expeditious determination of this issue and does not request an in-person hearing. Defendant requests an expedited response from the Commonwealth reporting their position to the court, consistent with the case law, providing that relief in this type of case must be speedy if it is to be effective. Stack versus Boyle, yada yada. Conclusion. For the foregoing reasons, Ms. Fitzsimmons respectfully asks the court to reconsider its order of incarceration on this date and return her to house arrest with the same conditions as ordered, accepting a random urine requirement as requested above in lieu of scram. If you haven't checked out the full recording, I definitely encourage that you do, because the whole thing is just, if you thought Bev was bad, I honestly think this woman is 30 times worse. This is unnecessarily cruel, and it leaves a very bad taste in my mouth for any other defendant that might cross paths with this judge. Just saying, oh, I got the power, I got the gavel, I can do whatever I want. Who cares what the rules say? I don't care. I made my mind up. You're annoying me. Have a nice day. So Brother Counsel did a really good job of breaking this down in his video he posted up yesterday, where he essentially calls out Kath and says, hey, you can't treat the Massachusetts statutes as your choose your own adventure book, because that's not what it says at all. You made a big mistake. So what were you doing exactly for that 5 to 10 minutes or whatever you needed to look over things? Popping a Klonopin? I don't know. So I'll include that video in my description box as well if you want to go and check that out. But for those of you whose brains are also fried by spending too much time scrolling through TikTok, here's his Spark Notes version.
And in fact, she also said, well, anyway, the affidavits are hearsay and the email is hearsay. There's an email from the probation officer, and that's also hearsay. So I can't consider that. In fact, she said that she gives that 0 weight. And we're going to see also, which we showed previously, that that's also at odds with the statute. The statute says that at these type of hearings, you don't need to follow the rules of evidence in a criminal trial. For these type of hearings, for revocation hearings, you could even rely on hearsay. So that was, again, another mistake that the judge made.
I understand there's, hundreds and thousands of pages of rules, and a lot of it contradicts other rules, and there's stuff that goes way over my head because I am not an attorney, as I've often said. But this stuff absolutely makes my teeth itch. Still, I do wonder why Bradl didn't have this doctor's note handy before the hearing. Although, not to beat the metaphorical dead horse, but anybody with 3rd grade critical thinking skills can surmise that if something happens to your chest and affects your lungs and your ribs are broken and you have to spend 52, 53 days in the hospital, then you're probably going to have a hard time breathing. Until at least you're fully healed and recovered, and even then it's probably going to have some kind of long-lasting effect. But who knows, maybe Kath just thought, hey, her lungs just need a little bit of a pep talk, that's all. A little tush-push.
Think this funny?
I will never forgive what they did to Deb at the end of Dexter. But it looks like I'm not the only one who's wondering why Bradl didn't have the doctor's note handy before the hearing either. And Jess Machado coming in clutch with some clarification. So I don't know if she got this directly from Bradl or from Martha Coakley or a different source, but it's her understanding that Bradl tried to get this doctor's note beforehand, but they only had 24 hours notice for the hearing, where, again, have we seen that happen before? And the doctor was unavailable. The second his clinic opened up today, that's when they were able to get this note. So in other words, Kath gave him less time to prep than a one-night stand at a Motel 6. Got it. So that is the latest regarding Kelsey Fitzsimmons. Obviously, once there is a ruling from the judge and we hear back from the Commonwealth if they have a response to this. I will be sure to update all you fine folk here. But in the meantime, if you want to write a letter to Kelsey, you can do so at this address. So I will include this information copy and pasted again in my description box below. She has a fund that you can donate to as well. The Young Jerks did a fundraiser for her over the weekend. You can check out that live stream on their channel, but if you want to donate some cash or you want to send her some warm wishes, you can do so by writing to her as well. That said, thank you so much for watching, and until next time.
I just want to get a Slurpee. I got lazy. I didn't want to walk.
Now, Casper Lincoln says he was using the sidewalk